Hello, my name is Michelle Mitchell. I would like to welcome you to today's talk by Professor Cassia Roth. It's such an honor for the History of Women and Gender to be co-sponsoring this talk with CLACS. It's my honor to turn things over to Professor Barbara Weinstein.
Thank you, Professor Mitchell. So it is, first I want to start by thanking both the History of Women and Gender program in the History Department and the Center for Latin American and Caribbean Studies at NYU, the new director, Dylan Robbins, and Assistant Director, Omar Dalacre, who has been indispensable in getting this set up, for their help and support, and welcome you all to this first event of the semester certainly for the History of Women and Gender, and perhaps for CLACS as well, though I think probably other events have happened for CLACS. It is my pleasure today to introduce Professor Cassia Roth of the University of Georgia History Department. She will be speaking today about her relatively new book, A Miscarriage of Justice, Women's Reproductive Lives and the Law in Early 20th Century Brazil. I wish I could distribute copies for Cassia to sign and for people to purchase, but that is the limit of book talks on Zoom. So, and which was published again 2020 by Stanford University Press. But before I say a bit more about that book, I want to say a few words about Cassia Roth's remarkable career thus far. Let me say, usually when you're introducing someone at Cassia's point in her career, it's a pretty short introduction because, you know, they're just getting started. But this is not the case with Professor Roth. Although it has been only 5 years since she earned her PhD in history from UCLA, she has already established herself as a major figure in the study of women, gender, race, and medicine in Brazil. And I would argue that her work should be of interest to anyone studying those themes in any geographic context. Aside from A Miscarriage of Justice, Cassia has published in numerous journals, including a co-authored article last year in Gender and History, Feminism, Frogs, and Fascism, the transnational activism of Brazil's Bertha Lutz. And also last year, In the Family Way, Incest, Fertility Control, and the Power of the Patriarchal Family in Brazil in Women's History Review. I think, Cassia, that was in an issue that you co-edited with Diana Payton. So yet another major activity and initiative. And one published in 2017 in Slavery and Abolition, entitled From Free Womb to Criminalized Woman, Fertility Control in Brazilian Slavery and Freedom. This latter article previews some of the issues she will be exploring in her very exciting new book project, which is, I think, well underway and has been awarded a National Endowment for the Humanities Fellowship, and which explores the role of enslaved Black women's fertility control in 19th century Brazil and their impact on the process of abolition of first the slave trade and then slavery itself. But to return to A Miscarriage of Justice, the book that we'll be talking about today, this is a path-breaking book that has been received with universal praise. To quote the closing package of one recent review, quote, "This beautifully written, meticulously researched, and brilliantly argued study of Brazilian women's experiences with abortion, miscarriage, stillbirth, and infanticide in the early decades of the 20th century would have been welcome at any time, but never more so than now," unquote. Actually, I wrote those lines. That's from my review of the book. And when I wrote those last words, I was thinking mainly about what was happening in Brazil at that time and the organized attempt to roll back the few rights with regard to reproductive rights, to roll back women's reproductive rights in Brazil under the recent regime there, and the few rights that women have won over the last few decades. But of course, in light of recent legal initiatives in Texas and Mississippi, clearly I'm not only thinking about Brazil. It is my sincere pleasure to introduce Professor Cassia Roth and have her speaking to us today about her terrific new book, which I urge everyone to read.
Well, thank you so much, Barbara, for that really wonderful introduction. And I'm really happy to be here today, half virtual, half in person a little bit later. So I just want to thank Barbara and the History Department, in particular the History of Women and Gender program, and Michelle Mitchell, as well as Omar Dawade and CLACS for organizing and hosting this talk, which has been very easy. So thank you so much. And I also want to thank the people who are providing technical and logistical support. So I just met Jorgina Quintana and Cynthia Vasquez. So thank you all again. And then thanks to everyone for attending. I know we all thought we would be off of Zoom and back to some interactions in person. But thank you again for taking the time. And then I just want to thank my late husband, Clayton, to whom I dedicate this book, which, as Barbara said, is titled The Miscarriage of Justice, Women's Reproductive Lives and the Law in Early 20th Century Brazil. And it is in paperback. So if you are worried that Stanford only has a hard copy, don't worry. So I'm just going to share my screen. Let's see if I can do this correctly. And we'll get started. Okay, so I'm just going to start with a story of Filomena Figueredo and her boyfriend Romeo, or Romeo, and you can't make this stuff up. This is in the archives. So in 1928, a midwife in the Brazilian city of Rio de Janeiro was charged for the abortion-related death of the 22-year-old school teacher who went by the nickname of Mena. In the trial, the prosecution presented as evidence a handwritten note, which you can see here on the screen, from Filomena to her boyfriend, Romeo. Quote, Romeo, I did what you advised me to do and what I should do, not only because I could not let the traces of an illicit love appear, but also for the great love that we have consecrated. I feel sick and I may not survive. And if so, I ask you to forgive my numerous mistakes. Of love alone I committed them, only to you, body and soul, I belonged, and only yours will I be, even in the hereafter, Mena, or Filomena, end quote. And you can see what was crossed out, what I crossed out in my translation there was actually crossed out in the note itself. So this firsthand account of a woman's reasons for seeking an abortion implies that honor and love influenced how she understood her reproductive decisions. Filomena suggests that Romeo had advised her to get an abortion, possibly in hope of avoiding a scandal. Both were single. Perhaps Romeo was unwilling to get married and take paternal responsibility. Perhaps Mena also wanted to avoid having a child. Nonetheless, her death remains a vivid reminder of how the criminalization of reproduction, here the illegality of abortion, which drove Filomena to an unlicensed and unsafe practitioner, had and have negative consequences for women. So we can imagine that perhaps Mena went to a clinic like this one. And this image is not from the same court case, but it's from a different court case where an unlicensed abortion practitioner's clinic was raided and the police took pictures. So a miscarriage of justice examines how women like Filomena Figueredo negotiated their reproductive lives in relation to legal and medical policy in early 20th century Rio de Janeiro, which was then Brazil's capital city. It traces the simultaneous medicalization of childbirth and the criminalization of fertility control, defined here as abortion and infanticide. So Brazil holds the singular status as the last country in the Western Hemisphere to abolish slavery, which it did in 1888. This development coincided with the end of monarchical rule and the beginning of restricted democratic politics, when, in 1889, a bloodless military coup overthrew the Brazilian monarchy, which lasted between 1822 and 1889, and instituted a republican form of government called the First Republic, which lasted until 1930. This set of political events presents a specific way to look at race, gender, reproduction, and the expansion of any modern state. Brazil's gradual abolition process had been based on enslaved women's reproductive capabilities, which is something I'm exploring more, as Professor Weinstein mentioned, in my new project. Great Britain first pressured Brazil to end the transatlantic slave trade in the 1820s, but Brazil only capitulated in 1850. After that, legislation gradually ended the institution, legislation that was only passed after the concerted effort of enslaved people. Most important, in 1871, the Brazilian legislature passed the law of the free womb, which conditionally freed all children born to enslaved mothers. Following final abolition in 1888, the expansion of Republican forms of governance continued to dictate the parameters of women's reproduction. In 1890, lawmakers passed their first piece of legislation, a penal code that increased women's criminal responsibility for the crimes of abortion and infanticide, and criminalized the illegal practice of medicine for the first time. For instance, in the 19th century, women could not be prosecuted for abortion. Under the 1890 code, they could. And it was also under the 1890 code that prosecutors charged the unlicensed midwife who caused Filomena's death. A year later, the Constitution of 1891, although enshrining equality regardless of race or color, closed women out of formal citizenship by implicitly restricting voting to literate males. Moreover, it still excluded the majority of the population from political participation through literacy requirements for suffrage. This, coupled with a near absence of a public education system, effectively shut the door of political citizenship for poor and working class men of all colors. The Republican implementation of liberal politics maintained formal citizenship as a white, wealthy, and masculine realm. So a realm of, let's say, physicians, but not of poor women who are seeking to end a pregnancy. In 1916, the country's first civil code further codified women's inequality, subordinating their decisions to the male head of household. Either the father or husband was in control of a woman's reproductive capacity. The code also theoretically elevated fetal rights above the mother's, making the state, for the first time, the patriarchal enforcer of fetal life. For example, Article 4 of the Civil Code stated that, quote, "The civil personality of man commences at his birth with life, but the law protects from conception the rights of the unborn person." Here, nascituro in Portuguese, end quote. As we can imagine, this change had real implications for women. For example, physicians relied on the Civil Code to valorize fetal rights over those of the mother. One forensic physician condemned therapeutic abortions in all circumstances. And here, therapeutic abortions would be in the case of the mother's life was in danger or medical reasons for the abortion. And he based his views in both civil law and religious doctrine. Citing the 1916 code, the forensic physician argued that, quote, "The fetus was a human being, a person with all of the prerogatives, with all the rights, including the right to life," end quote. The physician continued, "Not even the woman whose very life was threatened have the right to accept the sacrifice of their child to escape the imminence of death," end quote. Physicians were able to elevate fetal rights because the Civil Code did not protect maternal rights in the same manner. Married women, for example, married mothers, lacked patrio poder or legal rights over their children. Women also had to get their husband's permission to work outside the home and had no legal recourse to their own wages. It is clear that the legal realm was redefining women's reproductive rights. A similar process was occurring in the medical field. For example, municipal and national public health programs expanded their efforts to improve reproductive and maternal infant health through prenatal clinics. These actions increased access, if unevenly, to these services at the same time that they naturalized maternal instincts and gender divisions of labor. According to health officials, all women wanted to be mothers, and thus all women were meant to be caregivers in the home. So here's one example of that. This is a maternity primer, and in it, the physician, who was a woman, educates women on the best clothes to wear during pregnancy. Quote, the use of pants that are loose in the waist or shirt pants that are now in style is indispensable during pregnancy, and they should be ironed before worn, end quote. And I'm pretty sure here the husbands weren't doing the ironing. So politicians, jurists, and physicians clearly understood the value of women's reproduction as their country headed into a new century. So the book argues that the end of slavery and the rise of republicanism forced all women's reproductive lives, but particularly those of poor women and poor women of color, into regimes of institutional regulation, as various governmental and philanthropic entities intervened in women's reproduction. My argument is twofold. First, obstetricians and public health reformers worked to medicalize pregnancy and childbirth. Municipal and national governments showed a growing interest in creating a public health infrastructure geared toward reproductive and maternal infant health. They built new public maternity hospitals and expanded prenatal services. But a true change in hospital birth rates only occurred after World War II. Both a lack of state support, including inadequate public funding for hospitals, and a deep-rooted tradition of home births stymied these efforts to medicalize childbirth. So the tragic case of Isalina Vieira, which actually opens the book itself, illustrates governmental deficiencies. So on an early October morning in 1912, 29-year-old Vieira went into labor in Brazil in Rio de Janeiro. Accompanied by her female neighbor, she went to the nearby public maternity hospital, Maternidade Laranjeiras, and this is a slide of the outside of the hospital at around the time she would have given birth. Upon their arrival, though, the night doorman notified the women that the doctor had refused Vieira's entry. All the beds were occupied. Soon after, Vieira delivered her child on the hospital's sidewalk, and it died minutes later. A municipal guard who arrived after the birth returned to the hospital for help, but the doctor again denied Vieira's access. An ambulance later transported Vieira to another charity hospital for medical assistance. The medical student who had turned away the laboring Vieira told authorities that he had been loath to break the hospital's occupancy regulations. But the student's rigid decision was not his alone to make. The supervising physician testified that turning patients away, quote, could be reproduced because the number of beds the maternity hospital has is very small in relation to the women who seek out its services, end quote. The physician also refuted the idea that makeshift arrangements were possible in a situation like Vieira's, quote, a thing that should absolutely not be utilized in his hospital, whose cleanliness is indispensable for the well-being of the patients, end quote. Thus, health officials never effectively improved or expanded obstetric services during the First Republic, and high rates of miscarriage, stillbirth, and maternal mortality continued. This was in part because the science was rudimentary. The medical advancements that would drastically improve women's reproductive health, including penicillin and blood transfusions, only occurred in the 1940s. But it was also in part because the government did not adequately fund projects like the Maternidade de Laranjeiras, for example. Republican-era efforts, however, set the stage for later improvement in women's reproductive health, and these came about around mid-century. So this is just one example. And the graph demonstrates a mean of around 77 stillbirths per 1,000 total births from 1890 to 1940, which equates to roughly 1 out of every 8 births resulted in a stillbirth in the city of Rio de Janeiro. And just as a point of reference, Brazil's 2009 mean stillbirth rate was 10, so 10 compared to 77. And then Rio is the upper solid line, while Sao Paulo, Brazil's other major city, is the dotted line. And as you can see, the numbers show a consistently higher rate in Rio than in Sao Paulo, although they decline around the same time. And the steady decline you see that begin around the 1940s really is the arrival of antibiotics and blood transfusions. One possible reason, though, for Sao Paulo's consistently lower rate is that the city underwent successful and well-funded public health campaigns at the turn of the century. And these reforms reduced the prevalence of infectious disease and improved sanitation, although they did not address syphilis and labor and delivery conditions, which were the causes behind most stillbirths. So efforts to improve reproductive health remained, if not inexistent, at least unsuccessful. The second part of my argument contends that at the same time as these medical advancements or non-advancements are happening, the police and the criminal justice system increase their surveillance and prosecution of abortion and infanticide. In regard to the police, the Rio de Janeiro force consolidated and expanded in the early 20th century. And the force's structure was pretty unique for the time. It held a wide mandate in the early 20th century, where it exercised dual responsibilities, both providing social services and repressing crime. So on a citywide level, which is that top level there, the chief of police was in charge of the orphanage, the mental institutions, the municipal cemeteries, and prisons. In their respective precincts, which is the bottom level of the graph or of the chart, district police chiefs oversaw public health inspections, issued letters of admittance to public hospitals, and provided access to burial services. In the middle line, you can see that there's sort of these special divisions, including the forensic medical division. In the realm of reproduction, the police's dual responsibilities of both providing social services and repressing crime resulted in the force's arbitration of not only abortion and infanticide, but also pregnancy and birth. When a woman brought her stillborn child to the police precinct for burial assistance, for example, which she perhaps needed because she did not have enough money to pay for a private service, the district police chief decided whether to administer the necessary paperwork or criminally investigate. For example, in 1912, Portuguese immigrant Maria Inocencia's water broke. Her husband, an illiterate Portuguese milk vendor, called a licensed midwife. But after 24 hours, Inocencia was still in the early stages of labor, and a doctor was called. The physician could not discern fetal heartbeats, so he used forceps to extract the stillborn infant. And this is just a picture of auscultation, which was how physicians did and still do at times discern fetal heartbeats. This is an image of the various forceps that were used at the time during difficult childbirths. After the delivery, Inocencia's husband brought the infant as well as a signed death certificate to the local police precinct, hoping to avoid burial expenses. The police could send the cadaver to the charity hospital, which had a contract with the municipality for all public burial services. The official death certificate signed by the attending physician cited a stillbirth. Nevertheless, the police investigated the case as a possible infanticide. The autopsy determined that the child had died due to a prolonged delivery, which had caused a dislocation of the skull and compression of the brain. Officials did not mention that these injuries were probably caused post-mortem from the physician's use of forceps to extract the infant. That would require blaming a licensed physician rather than the working class couple. And we are left wondering why the police opened an investigation of infanticide in the first place, as the death certificate was in accordance with both federal, municipal, and police law. In other words, the police could have simply sent the stillborn infant to the morgue, and instead they opened a criminal investigation. Police involvement in all aspects of women's reproductive lives resulted in a criminal justice system that prosecuted abortion and infanticide with more frequency in the early 20th century. We can see this uptick by comparing the number of cases in Rio under the 1830 Criminal Code, which lasted until 1889, and the 1890 Penal Code in effect until 1940. During the 19th century, I found a total of 11 cases relating to abortion and infanticide. After 1890, I found 232. Despite the rise in the number of investigations and prosecutions, most women walked free from charges. Why? Most basically, the Rio de Janeiro criminal justice system did not have the capacity to efficiently investigate and try any crime. And bureaucratic delays resulted in frequent acquittals based on the statute of limitations. For example, about half of all infanticide cases were closed, or infanticide trials were closed due to bureaucratic delays. But the book argues that patriarchal understandings of women's legal responsibility also shape this trend. Legal practitioners, obstetricians, and the male public at large believe that all women, regardless of race or class, were inherently maternal, and thus none would rationally practice fertility control. If all women had the potential to reproduce respectable citizens, then they all held inherent maternal instincts, and thus honor, which they could defend in court. Women's sexual honor was defined as virginity or chastity outside of marriage, and motherhood and fidelity within it. The maternal defensive honor clause, here the dishonor of an out-of-wedlock child, was an explicit part of abortion and infanticide law in the 1890 code, and I've highlighted the honor clause in yellow here. And here we can see that the woman faced reduced prison time if the jury found her guilty of committing infanticide to hide the dishonor of having sex out of wedlock. But I argue that women fertility control had already lost both their sexual honor through supposed illicit sexuality and their maternal honor through their rejection of motherhood. This clause thus played a secondary role in the courts, particularly in the case of infanticide. Public prosecutors and defense lawyers employed medical ideas about postpartum hysteria to argue that women who practiced fertility control were irrational. Defense teams relied on the legal concept of temporary insanity to argue that infanticidal mothers were not criminally responsible, which was Article 27(4) of the Penal Code. Oh, that's coming up, sorry. Practically, this legal loophole allowed women found guilty of infanticide, but also found to be acting under a disturbance of the senses to walk free. So here is an example. In 1908, the 27-year-old single Portuguese immigrant, Gloria Lourenço da Silva, confessed to decapitating and dismembering her newborn child. Her defense lawyer contended that Silva only mutilated the infant after its death, when she acted under, quote, a complete perturbation or even a privation of the senses and intellect, end quote. He argued that Silva's past behavior in which she showed affection for other children and thus she did not, quote, voluntarily and consciously practice such a violent crime, end quote. And this is an image from the court case itself. And so this is the infant's head. And so this was what the lawyer had to defend Gloria from. He argued that Silva was not an innate criminal, but rather a woman possessing a, quote, simple and childlike nature. A woman who had succumbed to irrational behavior in a specific moment. She still held the maternal instincts natural to all women. In Silva's case, the jury believed her defense and acquitted her under Article 27, paragraph 4. Abortion and infanticide jurisprudence in Rio de Janeiro was marked by aggressive police investigations, but lenient sentencing practices. But these trends reinforce women's subordinate legal status at large. The law and its practitioners viewed women as legally irresponsible and thus juridical children with no legal personhood, ultimately maintaining a patriarchal state control over definitions of motherhood, sexual honor, and women's rights. The expanded state surveillance of women's reproduction during the First Republic set the stage for later government action. In 1930, Getúlio Vargas ended Brazil's Republican experiment by taking power as provisional president through a coup. As the decade progressed, Vargas took on a populist mantle to expand his base, providing social and economic rights in exchange for support. His corporatist model granted specific social groups political influence through personal ties based on group identity. Protective labor legislation, including maternity leave and political reforms such as women's suffrage, which was passed in 1932, were coupled with expanded state control. Women did not receive rights based on individual claims to citizenship, but rather because of their childbearing capabilities. If you weren't a mother, you didn't receive rights. In the realm of gender, these policies reinforced the maternal nature of women's citizenship. Moreover, maternal infant health became a principal concern of the federal government and increasingly tied to its nationalistic endeavors. So here's one propaganda message from Vargas, which I'm sure Professor Weinstein is familiar with. So children, learning in the home and at school the religion of the patria, you will bring to your practical life all of the probability of success. Only love constructs, and by forcefully loving Brazil, you will conduct it to its highest destinies among nations, achieving the desires of aggrandizement nestled in the heart of every Brazilian, end quote. By the time Vargas dissolved parliament and instated his corporatist dictatorship, the Estado Novo, or New State, in 1937, which lasted until 1945, the policing of women's reproduction had shifted from the judicial to the public health realm. For example, the police no longer issued admittance letters to public hospitals. The 1935 abortion trial of Alcinda Ferreira de Souza, a 27-year-old widowed woman, shows this shift. Souza became pregnant from her boyfriend, 30-year-old José Dorval Cordeiro, who was married to someone else. She knew that an out-of-wedlock pregnancy would bring dishonor to her family. Quote, in the face of her civil status as a widow, she could not conceive a child, as such an action would cause a scandal and sadness for her parents, end quote. As such, she thought out an abortion. A male physician, quote, introduced something into her vagina, which caused her to miscarry. Because she did not expel all the fetal and placental tissue, Alcinda got an infection and took a public ambulance to the nearest public maternity hospital, where physicians completed a curettage procedure, or scraping the infected tissue from the uterus. And notice here that she didn't have to go to the police first to get the access to the hospital. She just went straight to the hospital. That was a new advancement. After completing the procedure, the physicians denounced her to the police. So it didn't really matter. The prosecutor charged Alcinda, her boyfriend, and the physician with illegal abortion. All were acquitted on insufficient evidence. So as we can see, the law continued to criminalize fertility control, but physicians and not the police were now on the front lines. The writings and actions of physicians and legal practitioners demonstrate that combating abortion was built into the public health apparatuses created to improve women's overall reproductive health. So the racial legacy of slavery also influenced both police practice and reproductive health outcomes. Brazil's 4th century history of slavery, in which the country forcibly imported nearly 5 million enslaved Africans, meant that in the period following abolition in 1888, racist science shaped physicians' valorization of motherhood and rejection of fertility control. And just as an idea, nearly 40% of Rio's population was of African descent in 1890. Most generally, the global climate of the late 19th century influenced Brazilian physicians' approach to race, regardless of gender. In the lead up to abolition, leading medical thinkers embraced scientific racism, which purported that Afro-descended peoples were closer on the evolutionary scale to animals than Europeans. In doing so, they reconceptualized racial hierarchies in the face of democracy and ultimately created a, quote, differential access to citizenship. During the Republican period, Brazilian scientific racism morphed into an early 20th century theory of whitening. This purported that miscegenation, or interracial sex, would lead to the inevitable whitening of the Brazilian population. Racist science became gendered in that it viewed interracial sexuality as part of the solution to Brazil's alleged racial problem. So this chart is just a table of whitening that demonstrates what they, in 1913, what leading scientists thought would happen to the Brazilian population by the year 2012, where it would be 80% white. And just in 2010, a little more than half of Brazil's population was of African descent. The whitening thesis also coincided with the rise of the Brazilian eugenics movement in the 1920s, which focused on social welfare and public health campaigns as the keys to quote unquote race improvement. So in Brazil, unlike in the United States and Germany, better hygiene and not sterilization was the key to a superior nation. Most Brazilian eugenicists and obstetricians believe that all Brazilian women, regardless of race or class, should reproduce. In the 1930s, Vargas co-opted these racial ideas through his support of Brazil's supposed racial democracy. And we can think back to his propaganda message for children, which was decidedly white. Yet this change did not address the underlying assumption that whiteness was the key to Brazil's future. Vargas's erasure of any outward mention of race by focusing on the Brazilian citizen further disguised 20th century hierarchies by eliminating any discussion of the correlation between skin color and inequality. Thus, despite changes in racial thought, the systemic inequalities that define post-abolition Brazil remained unchallenged. People of color had more limited economic opportunities and worse health outcomes compared to their white counterparts. So this is just an image of 18-year-old Mercedes dos Santos. It's one of the only images I have of a woman, and she died from hemorrhaging after an incomplete miscarriage. It is from, I can't see the, from 1933. And the police had included this image of her in the court case itself. So this book argues that women's reproductive lives became a focus of an expanding state after the abolition of slavery in 1888, the onset of republicanism in 1889, and the strengthening of the federal government in early 20th century Rio de Janeiro, Brazil. As bureaucratic institutions began focusing on women's reproduction, they co-opted patriarchal control from the family. The criminal justice system, first the police and then the courts, initially mediated women's reproductive lives in the Republican period. As the state expanded and federalized under Getúlio Vargas in the 1930s, women's reproduction moved under the auspices of the public health system, whose practitioners expanded access to clinical care and, at the same time, extended the reach of the law. The increased criminalization of abortion and infanticide, as well as the heightened police and medical attention toward pregnancy and childbirth, shaped the ways in which women experience their reproductive lives. Women's deaths from illegal abortions or their fear of being investigated for a miscarriage shrouded the practices in secrecy. This in turn made them more dangerous. Yet women and their partners continued to challenge state and societal prescriptions. After all, women in Brazil had been giving birth, having abortions, and killing their babies long before medical and legal apparatuses took concerted notice in the early 20th century. Women and men had sex out of wedlock. They bore children at home in unhygienic conditions. They drank herbal teas to provoke abortions, and they murdered their infants. But they raised their living children, notwithstanding structural inequalities. Filomena at the beginning of this talk is case in point. She did not survive the illegal abortion procedure she underwent in 1928, but Filomena, like the other women featured in the book, negotiated their reproductive lives against all odds. And it is a reminder that women, whether it be in Brazil or in Texas, will continue to do so no matter the consequences. Thank you.
Well, thank you, Cassia. I wish we could have a loud round of applause for that talk, but thank you very much. And I think you did an extraordinary job of kind of giving us a synthesis of your arguments in a very complex book. And so let me just start off. And I have a couple of questions. Well, one is a short, I think the answer is short. I know yes, no questions are not a good idea, but one of the things that I was struck in reading the book is that the Catholic Church is almost absent in the book. And I think most people who don't study Brazil would say, if you told them, oh, I'm doing a book about limitations on women's reproductive rights in Brazil, would say, oh, well, it's a Catholic society. And so that's why. That would be their short answer. So I guess it's a two-part question, really. Was the Catholic Church in any way engaged, or is this really about, ironically, a period when Brazil is becoming more secular, more linked to positivism, or at least the elites are, so that sort of ironically, the Catholic Church is even less likely to be involved in the prohibition of women's reproductive rights?
So that's a great question. I think partly it's probably here I'm critiquing myself, an issue of sources. You know, I didn't look at institutional Catholic sources, and I could have, but, you know, for anyone writing a book, you can keep writing it forever. So it's best to just send it to your reviewers. But so I think so I didn't look at sort of institutional church efforts at the time. However, I did look in some of my later work, I've looked at what the church was saying about eugenics, what it was saying about sterilization, how it accepted, there's major Catholic doctrine occurring during this time period. So abortion becomes an you can become excommunicated in the late 19th century because of abortion. Casti Connubii comes out in 1930, which rejects any form of artificial birth control, as well as eugenics. So there's definitely these Catholic ideas that are swirling around. I didn't see the Catholic Church as a concerted effort, but again, I think that could be an issue of sources, and I would hope that perhaps a future scholar could look at the institutional aspects. However, you're right that this is a period of a separation of church and state. But obstetricians and legal practitioners were very religious, and it comes out in their writings. So that the forensic specialist who I quoted, who was talking about fetal rights, for example, was incredible. He was very Catholic, and he was a leading physician at the time in that field, and all of his writings were infused with Catholic a Catholic worldview. So you definitely see that. And for those of you who haven't read the book as well, people were also religious. I didn't see a lot in the court cases, religious justifications for anything, but in denouncing other people, let's say, I have a chapter on denunciations and gossip about abortion and infanticide, Catholic worldviews or Christian worldviews often came into play. And then I'll just add a little bit to, so I don't ramble on, is that, you know, today in Brazil and in the United States, it's not Catholicism really, it's evangelicalism, right? That's the strongest effort. But that's a great question. And I think, you know, future work should focus on that as well. Thank you.
So let me just say that, you know, because Cassia started off by saying, you know, there are limits to how much research you can do. But I do want to, you know, say that it is remarkable, the research that you've done for this book. I mean, I think that people who have not done, which is most of us, have not done research in Brazilian legal archives and court records, often have no idea just how arduous this kind of research can be. So certainly, I think you don't have to apologize for not having done every kind of research imaginable for this book. First, I'll start with Professor Rebecca Carl of the NYU History Department. She's slightly different from Barbara's, but on the theme of religion and abortion. We know that anti-abortion is rarely about abortion as such. Your work seems to show how this is always already about power, social and legal power. Is this the argument more generally? That is, even if you weren't focused on Catholicism, is your argument more about the nature of legal, social, political power over women's bodies?
Yes, thank you. That's an excellent question. And I feel like maybe you should have written part of the book, because, you know, when someone else synthesizes what you're thinking really well, that it's exactly about power. In general, I am interested in how power affects the structures that then govern how we live our daily lives. As a human being, I'm interested in how we live our daily lives within these sort of swirling issues of power that are embedded in institutions. I would also put medical power, right? It's legal, social, political, and medical power. This is a period when the medical field is consolidating, and medical advances are actually beginning to change people's health outcomes. So it is always about power. I mean, telling someone, right, that abortion, anti-abortion politics, reproductive politics are always about power. And I saw earlier, I don't know if she's still here, but Natalie Kimball, who's a professor at CUNY Staten Island, who just wrote a great book on abortion in Highland, Bolivia, also demonstrates this issue of power, right? Of who has power, who gets to say what happens, and what does it mean when a woman does something that could perhaps take away power. And, you know, I used to get critiqued a lot. Oh, patriarchy, patriarchy, patriarchy. Like you have to define what that means. But sometimes I'm like, it just is, you know, it's about patriarchal power and controlling over what women can do. So I think that that's a great way of putting it. Thank you.
So Joanne Flores Villalobos, who's in the assistant professor of history at the University of Southern California and a former NYU, and recent NYU PhD, says, Joanne says, thank you for this wonderful talk, Cassia. I can't wait to read the whole book. I have a ton of questions. Oh, Joanne, you always have a ton of questions, but for now, just one, given the huge impact of jury decisions on these cases. Can you tell us anything about the jury selection process or jury makeups? Who was allowed, et cetera, et cetera? I guess I want to think about what regular people were bringing to these cases.
That's a great question. So the first thing I'll say is that most cases did not make it to the jury. So this is a very small number of cases. This is because most investigations never made it to a court case. They were closed either due to insufficient evidence or bureaucratic delays or the fact that it was just a stillbirth and not an infanticide, right? And of the investigations that did make it to court, abortion trials were not jury trials. They were what today you'd call a bench trial, where the judge decides from the bench. So the only trials were infanticide trials. Who made up the jury? So it's voters, right? And who could vote? Literate men. I think let's say around, I can't remember Joseph Love's, statistics on voting, but by the end of the First Republic, it's no more than 5% of the vote of the population is voting. And that might be high. It might be more like 3%, right? So it's a very elite group of men who are voting. And it's just the jury selection was a lottery. They would bring so many men in and then some would be excused. The court cases don't explain why some people are excused. So we don't have insight into sort of conflicts of interest. But I would say that the juries are from the elite male public. Not from, they weren't women. And it often reminded me of, there's a book or a short story called A Jury of Her Peers. And I don't remember who wrote it, but so it was a very different sort of social and gender strata, than the women who were on trial. And I don't know if you wanted to follow up when you say regular people, if you meant the jury members or the people in the cases themselves. So if you want to just write a follow-up, I can better answer that part. Thank you.
So Natalie says, thank you, Cassia, for the fantastic talk. It is a pleasure to be here. I was wondering if your sources gave you any sense of any competing rights frameworks that might have been at work in Brazil at this time, or the ways that women thought of their own pregnancies and the decisions they made about them. Were there, for instance, any indigenous or African conceptualizations of reproductive decision-making at work in sources that show women's own perspectives on their pregnancies? I am a big fan of your work. I own your book and look forward to reading it in depth.
Well, thank you so much, Tasha. It's nice to see you. And I shouted out to your book earlier. So it's a great book as well, if you're interested in these topics and themes. And Tasha's book also works a lot with oral history. So if you're interested in like different ways to approach some of the same issues and how different sources can give you different perspectives. So this is a very interesting question. I didn't see or find in my sources, which are heavily mediated, right? Legal court cases, medical resources, clinical records, explicit Afro-descendant or indigenous frameworks, but I did see generalized frameworks for how poor women who at times their skin color was mentioned, right, or their indigeneity was mentioned, approached childbirth. And it was a communal thing. It was not necessarily seen as something out of the ordinary, right? So women are working up until the moment of delivery, it seems. And that could be because of necessity, right? And there's also not this sort of view of necessarily needing to rely on another, on outside help or structures during childbirth and delivery. In relation to sort of understanding different frameworks for the choice or the constrained choice to end a pregnancy, that's also really heavily mediated in these sources, and I don't see any sort of specific examples of that from women's own words. And that is something I think in my new project, which is going back into the 19th century and looking at enslaved women's reproductive practices, really that's a very general look at or description, is to go back to what West African practices were at the time and to try to trace different practices back in, to Brazil. I just didn't see them that much in the sources I had for this book. So it's kind of a disappointing answer.
So one of the things I was thinking about was, as I was reading your book, is the book that, of course, it most reminds me of, you won't be surprised, is Sue Ann Caulfield's book, In Defense of Honor, about deflowering cases in the Rio courts, a book that started out as her dissertation at NYU under Warren Dean, and with Warren Dean as her advisor. And so one of her arguments in that book is that the women, or really in many cases girls, who were coming to court with their mothers to try to, in effect, coerce a man into marrying the girl or woman he had dishonored, that their testimony and the way they presented themselves and their actions shaped the way in which jurists thought about and legal experts thought about these issues. And I think there's some of that in your book as well. But I was just wondering if you could say, to what extent, but I think the direction is, I don't want to say top down, but I think you don't get a sense of a lot of agency on the part of most of the women. I mean, there are definitely exceptions, but I was just wondering, to what extent do you think this is the context that you're dealing with? Do you feel like there is a similar kind of interaction between sort of expert knowledge and the way in which women are approaching these issues?
That's an excellent question. And I would say no. I would say I think it is the topic. I think what I find is just a pretty blanket condemnation of abortion, and a rightfully condemnation of infanticide as well, but really a lack of understanding of what leads to infanticide. That there's no sort of understanding that I get of how judges or jury members, not jurists, jury members, but even jurists are incorporating what women are doing into their view of this. I think there's actually a trend toward being more conservative over time, let's say in the medical profession. So obstetricians are seeing the results of illegal abortions in their practices, and the obstetric profession becomes a little bit more conservative over time. So rather than sort of incorporating what they're seeing or what women are doing, it's sort of this doubling down on abortion is bad, abortion shouldn't occur. And so I do think that there is a difference when you're studying something like sex, right? And then the sort of consequences of sex, abortion. I do see sort of a break in how there's any sort of give and take. And I don't, I think you're right about agency is hard to find. I use the term negotiation because, there's always this back and forth in history of like, do we give historical actors too much agency because we wanted them to have it because of who we are as historians? Do we not give them enough agency? And that's always sort of a back and forth. But, my book was really depressing to write. It'll probably be depressing to read. And it's because I didn't see a lot of ability to sort of overcome or change these issues. Abortion is still illegal in Brazil. And in most cases, and the few changes that, as Barbara mentioned, you mentioned at the beginning, occurred, don't really have much to do with women at all. It has to do with the fact, so I think it's in 2004, or 2008, the Supreme Court passed an exception. So abortion is illegal in all cases except for incest, rape, threat to the mother's life, and now in cases of fetal anencephaly, which is the fetus or child is born without a brain and it cannot live outside the womb. So granting that exception isn't giving women more rights. It's just, right? And a similar exception has been feminist scholars have been pushing for that in relation to Zika and microcephaly, but that's different because the fetus can survive and it can be it can live for years, right? So I feel like I need to pull in my strains of thought here. But back to the original question, I would say no, I don't see a lot of that give and take. And I would be interested in what other people see if they're studying these subjects. And also, I would have loved to do oral histories with these women. The time period obviously doesn't allow that, but I think that approaching the topic from different sources is also another way to perhaps see different sides of it.
Thank you. I know this is a frustration that we all have, because even now when we're more even critical of the concept of agency, we also still want to work with it. So now we do in fact have some more questions. So first from Professor Nicole Eustace of the Eustace of the History Department at NYU. She says, thanks for a great talk on an issue with a great deal of contemporary resonance. Can you discuss the historical and/or analytical reasons for your choice to consider infanticide and abortion together as fertility control practices?
That's a great question, and one I still think about a lot as I do more and more research. Maybe I wouldn't. It's not that I wouldn't consider them together, but I maybe wouldn't call it fertility control. But the historical reason is that abortion and infanticide are right next to each other in the penal code, and they have very similar, the criminalization of both are similar in word, in structure and tone. They both had honor clauses, right? Contraception was not illegal. And of course, abortion is not contraception because you're already pregnant. So that was sort of the historical reason. Another historical reason, and this is not that historical necessarily, it continues today, is that physicians and lawyers often had a hard time differentiating between what was an abortion and what was an infanticide. So the obstetric definition is, around 6 months that in the early 20th century of when it's after which the fetus becomes viable, and then that becomes a stillbirth, from a miscarriage to a stillbirth. But there was a lot of legal discussions about what an abortion was, if it was actually infanticide. And so there was confusion between the two amongst legal practitioners, as well as physicians and medical scholars. So there is a case I found where the public prosecutor tried to charge a woman for both abortion and infanticide. And then the judge was like, you can't do that, but to sort of demonstrate that legal gray area, fuzzy area. And it's because abortion, and I could be getting this wrong, it's in, I think, it's in a chapter of my book where abortion refers to the expulsion of the fetus rather than it's the fetal demise, right? And so there was all of these legal confusions about what should be considered what. So that's the sort of historical reason. The analytical reason is, I think that's a good question. I think one of the things that surprised me the most is that there wasn't necessarily a connection between women who committed abortion and women who committed infanticide. So the women who committed infanticide were poorer, younger, had no social capital, no social network, right? There's a distinction between who practiced abortion and who practiced infanticide. And it's sort of, I stumbled upon, I found cases of abortion and infanticide in the archive. So I just sort of went with it from there. And then after understanding the law, there's some great discussions over what should be considered fertility control or fertility regulation, because fertility control could also refer to things like infertility treatments, right? Trying to get pregnant. So I use it sort of in the negative sense. And I think that actually it could be a broader term. And that's something that scholars talk about as well. So I think that somewhat answers your question before I keep going on. Thank you for that question.
Yeah, let me just say quickly that I don't know if I found reading your book in general depressing, but reading about the infanticide cases certainly were, precisely because the women seemed so desperate and alone. So, okay, so next is from Mary Roldan. Hi, Mary, professor of history at Hunter College and the CUNY Graduate Center. And Mary says, thank you for this terrific talk. I am definitely looking forward to reading your book. I'm wondering a bit about how information about abortionists circulated in society and women learned about who they were. Was there any concerted effort to identify them by the state and prosecute or shut them down?
That's a great question. Ways abortionists, including male physicians or male not physicians and female midwives or unlicensed midwives and practitioners, was they advertised in the newspaper. Of course, you know, the literacy rates aren't that high, but people read the newspaper to other people, right? And then people tell other people about that. So it's both sort of the typical, you're thinking like Madame Restell, right? Advertising in the newspaper in 19th century New York. You have that, those newspaper advertisements. And then you have a lot of word of mouth from women who know women who went there. So those are the two ways I found that they're circulating information. And one of the best ways to think of how widely it's circulating is how the hysteria levels in the medical profession, right? Like the higher the hysteria levels among male physicians who are trying to crack down on it, the more you know they're circulating. And it was pretty high. So there was this debate in the Brazilian equivalent of the AMA or their big medical association. It went on for like 4 years in their meetings about how they should crack down on illegal abortion in the city of Rio, which was, quote, a biosocial problem. And I'm like, Foucault could not have me. I mean, like they said, quote, biosocial. It's one of those moments as a historian, if you use Foucault, you're like, see, there's a reason. And one of their main issues was the advertisements, right? The advertisements for these services, which were often, they were euphemisms, but people knew about them. And some of the midwives that show up in the court cases, they would have to move a lot. So there'd be like, oh, they moved their addresses throughout. So I think they're trying to avoid prosecution, right? So you can see the uproar in the medical profession, and then you can see how midwives, their strategies of avoiding that prosecution, of moving addresses, of those sort of tactics. And there was in addition to the sort of use of the illegal practice of medicine statute to crack down on midwives who were unlicensed, who were often providing abortions. There was sort of a citywide circular in 1930 where the chief of police said, we're going to give this precinct special powers to combat abortion, but I didn't actually really see a change in the rate of investigations. So, you know, those are sort of the typical ways of advertising, and then trying to go to crack down on those clinics. So
Sarah Sklar, who is finishing up her PhD in history at NYU, first says, thank you for this talk. Could you speak a bit more about the concept of madness? You write about a feminized conception of madness, irrationality, hysteria, but is there a masculine counterpart or an allegedly gender neutral one?
That's a great question. And it reminds me of Susan Bessie's article, which talks about wife killers in around the same time period. And those men and their defenses also used that Article 27, paragraph 4. So that was not specific to infanticide, right? That could be used in any crime. So it was used in this sort of momentary loss of reason for men when they killed their wives because their wives were doing something that caused their husbands to become so outraged, usually adultery, right? So it was used for men. I think with the specific sort of postpartum aspect is that the defense lawyers who are defending women who have done pretty horrific things, like I showed that one image, which is graphic, to demonstrate like what the defense lawyer, the jury saw that image, right? So they really do rely on this momentary loss because of the recent, the childbirth, being alone, That's what I saw for women. But I also didn't look at other types of cases, criminal cases that relied on that article of the penal code. So I'm interested in, for instance, obviously suicide, the person committed suicide, so they can't go to trial, but it would be interesting in police investigations to see if that was brought up in relation to suicide at the time, right? And I think sort of if you're interested in that, in the issue of madness per se and the gendered constructs of it, looking at different crimes and how they fit, how those are used in the defenses or prosecutions of different crimes, if that makes sense. So in the law, it was gender neutral. How it was practiced from my research and from Susan Bessie's demonstrates a gendered use of it in the courts.
Jen Zelmer says, I joined late, so I apologize if this was already covered, but are there examples of men being prosecuted for infanticide? Were their sentences less than women? And she says, also, I cannot wait to read your book.
Well, thank you. I saw your question and I was like racking my brain. I don't have a copy of my book with me. Men could be prosecuted for infanticide under the 1890 Penal Code. There were some men who were investigated. I mean, maybe correct me once you read my book, but under the 1890 Penal Code, I don't think any men were actually brought to trial, although they could have been. I do have some cases. One of the articles that Barbara mentioned that I wrote, that men were prosecuted, they were prosecuted if they were also being prosecuted for incest. So if fathers were raping their daughters or other female family members and then committed infanticide or forced the woman to have an abortion, they would be prosecuted. So it was the sort of, it wasn't that the men that it seems to me that the law and its practitioners wasn't necessarily interested in prosecuting men for infanticide, but rather when the outer limits of patriarchal control really brushed up against what the state thought was okay, which was incestuous relationships. Men were prosecuted for abortion, both male practitioners and men involved in it. The only people who actually went to prison, though, were women. So 2 women went to prison for infanticide out of all the 232 cases I had. So you can see that there's a very low rate of incarceration in compared to the sort of surveillance of the state.
Okay, so I believe Joanne that I don't see another question. So Joanne says, I have another question. If no one else, Flores Villalobos, if no one else has another question. So she says, there is an almost verbatim repetition of the honor clause in Panamanian and Colombian legal codes for infanticide and abortion, but it's not surprising to me that written law had these echoes throughout the region. Do you have any sense whether there's also a broader regional pattern of the application of the law, not prosecuting these cases and mostly acquitting women? I don't expect you to know every nation's legal environment, of course, more just wondering if Brazil presented a unique case in this or not.
Yeah, that's a great question. So one, yes, honor clauses are very common in Latin America. They're common in Italian, in French, in Spanish legal codes as well. They were part of German legal codes. So a lot of the language of legal codes in Latin America borrows from codes that are coming out of Europe as well. And there's debates about, what should be considered infanticide, if honor should be included or not. And so I think there are broad patterns, and this has to do with like the structure of patriarchal law and society in Western nations, that I think you can trace some overarching trends. I think though that, I was thinking about Argentina, and women did go to prison for infanticide, and Argentina didn't use this momentary lapse of madness. And so I think what as scholars, as we're making sort of regional, national, international comparisons, is to look at the law around abortion and infanticide, but also what other aspects of the law come into these court cases. Because because legal tenets or codifications that have nothing to do with abortion and infanticide can play very important roles in how they play out in the courts. So I think that this subject, deserves more attention in Latin America. I think it deserves more attention in the United States. I think we can start viewing the United States as each state as sort of a nation unto itself in relation to how it's prosecuting or criminalizing abortion, and that, to think about these sort of interlocking parts of the law itself and then other aspects of the law that play into the case. And I was going to say something else. Oh, in relation to I forgot to mention in relation to Jen's comment, is that the 1940 Penal Code, which was passed, I decided to end my study because I didn't want to keep going, but which is still the criminal or the penal code in effect today in Brazil, actually made infanticide only a mother in a state of madness, they don't use that term, could commit infanticide. So there is a change in the law where a father can't commit infanticide after 1940, it's just homicide. And homicide does have a harsher penalty, both under the 1890 Penal Code and under the 1940 Code. So I meant to mention that earlier, but.
So Natalie Kimball, or Tasha, has a comment, says, Joanne, I can say that in Bolivia in the second half of the 20th century, prosecutions of women in connection with abortion or of those performing abortions was very rare. Usually a settlement or bribe was arranged. So anyhow, so that just to kind of fill that out a bit. And I do want to say that those of you who've read Rachel Nolan's remarkable article on the draconian anti-abortion law in El Salvador that appeared in Harper's, I think, many people think about rolling back abortion rights and prohibiting abortion in various ways is going back to the status quo ante. But in fact, the new abortion laws are far more draconian and punitive than the earlier laws were in practice, even if on paper sometimes they seemed similar. So
yeah, that's a great point. Sort of like there's waves of criminalization and decriminalization in relation to abortion rights, and we can slide backwards, and it's to look at both what's happening on paper and then what's happening in practice, because as Tasha Kimball was just saying, you can have a law that criminalizes it, but is that actually who is being prosecuted?
Yeah, so we have some comments. Sarah Slaw said also the current case in Nicaragua, which is she's looking at, and Joanne said, yes, I was also thinking about Rachel's work because the new abortion laws there criminalize women so harshly. So, and thanks for that context.
I think also what's interesting is that the laws in El Salvador and Nicaragua, they criminalize miscarriage. And so they criminalize what I found in my book, they criminalize normal events. And the law in Texas at 6 weeks will criminalize some miscarriages. Many women will miscarry in their first trimester, right? And so so like police chiefs in early 20th century Rio, they're not trained as physicians, they're trained as lawyers. So they don't understand what's a miscarriage and what's an abortion. And in fact, often you cannot tell, right? So there's this sort of, it expands out where it criminalizes every aspect of a woman's life. And then you're saying, well, if you fall, is it your fault you fell and had a miscarriage, right? Like it expands out so that your pregnancy is criminalized or potentially criminalized. This is a sort of theoretical discussion about women who use drugs during pregnancy and the use of sort of these new laws protecting fetal rights and what that does to criminalize the mothers, right? I see there's another comment, so I'll be quiet here.
So this is from Mary Roldan. She says, medical doctors, at least judging from, let me just make sure I have, at least judging from the Colombian case, with which I'm more familiar, were attending international professional meetings too with greater regularity beginning in the late 19th and early 20th century. I was also thinking that part of what is going on with obstetrics and medicine more generally, where women professionals like midwives were increasingly demonized by male medical professionals, in part because this is a moment when the medical profession is lobbying to organize professional associations and to monopolize the exercise of medicine, including against traditional healers who are often men and exclude women.
Yes, that's definitely going on in the case here. I mean, I think I have cases of traditional healers who are men who are also investigated, if not brought to trial, right? And that, you know, I always want to remember that this is, being a physician is your job, right? These men are also very interested in making money, which is understandable if it's their position. And you know, unlicensed midwives were also interested in making money. So everyone, if this is an economic aspect as well. I remember one midwife had a card that said, like, one midwife allowed you to pay for your abortion or your delivery or your abortion in installments. And another woman had a card that said you had to pay up front, right? So it was just like the financial aspects are always there. But when you're trying to monopolize an industry, you want to make sure that you are getting the patients, not someone else. And one way to do that is to demonize certain practices, whether or not you actually think that's the case or not. Although most of the male obstetricians look down on these other types of practitioners.
There's another question from Joanne. She says, oh yeah, Mary's comment reminded me of another question I have, just out of curiosity. In the chapter you mentioned Ongina Constantino Neves, who ran an illegal gynecological clinic. Do you know anything else about her or what that clinic might provide?
Yes, I can't remember exactly what the clinic is anymore. I would have to look in the book. But I did have an article that came out after the book, which was stuff I took out from the book about a lot of these illegal clinics. They provided a lot of different services. They provided childbirth, abortion, sexually transmitted infection, care or of those infections. They also provided sterilization treatments. So these were not your normal sterilization treatments, but treatments where they would inject caustic substances or hot water into the uterus, which would cause the uterine lining to slough off, which was could be very painful, right? Well, I haven't done it, but I can only imagine because reading about it made my stomach hurt. But women would go back and back to these clinics for these treatments. So they sort of provided the range of reproductive health that you would think of, like I'm not saying it was a Planned Parenthood, but this sort of, that it's not actually, abortion is probably not the main service they're providing. It's less than 1% of what they provide, right? That these women need care for their reproductive health, and that these clinics are places where they can get sort of these range of services that range from childbirth and postpartum care to actual, in that case, contraceptive treatments, although I don't even know if you could call it contraception because you don't know if the woman was pregnant or not when she underwent these treatments. So, but the picture, that image from a clinic, there are some images there, especially in the 30s when police start raiding clinics more often and they take pictures of everything. So you can see that they have a lot of tools. They have speculums, they have silk for stitches, which would often be if after childbirth you needed stitches, not just if you had a surgery, right? So they're providing a range of services. So thank you, everyone. Those were really great questions.
Yeah, well, thank you, Cassia. This was a wonderful discussion, a wonderful talk, a wonderful discussion. Thank you for everyone for being here. Again, I wish, let's all give her, Cassia, a round of virtual applause. And I would like to end with a quote from the book I guess it's at the end of chapter 7. You say, most importantly, fertility control was not necessarily the antithesis of motherhood. And I think that that's such an important point and such a succinct way of expressing that. So I want to thank you for that and for all the remarkable research that you've done. And thank you all for your questions, which were
also.
Thank
you so much, everyone.